5 seconds. The principal issue raised in this public interest litigation relates to the alleged malfunctioning of the Vigilance Bureau Punjab regarding investigation and registration of FIRs, especially with reference to guidelines dated 6/3/2000 issued by the Vigilance Bureau. The core prayer in this petition under Article 226 is for directions to the learned trial courts to stay the proceedings in 4 FIRs bearing the following particulars and consequently for necessary directions summoning the entire record of the said 4 cases from the trial courts where they are pending to enable this court to examine the alleged illegalities committed by the Vigilance Bureau Punjab. The case, in short, is that the state government in the Vigilance Bureau has issued guidelines dated 6/3/2000 for streamlining the vigilance machinery in the state of Punjab. These guidelines issued by the Vigilance Bureau bracketed P1 have been exhaustively considered by a division bench of this court in CWP 9256 of 2000 titled Ashok Chaudhary versus State of Punjab and others by the judgment dated 15/5/2006. In this case, the constitutionality of the circular dated 6/3/2000 was challenged. On a threadbare examination of the circular, the division bench opined as follows. Para. The challenge to the circular would be valid if the same can be held to restrict the duties cast on station house officers under Chapter 12, especially under Section 154 of the Code. There can be no manner of doubt that the Code has been enacted by the Parliament in exercise of powers conferred on it under Article 245 of the Constitution of India and List 3, Entry Number 2 of the 7th Schedule of the Constitution of India. There is also no doubt that List 3 is a list in relation to which both the centre and the states can legislate. It would be open to the state legislature to modify any provision relating to criminal laws, and this amendment would operate within the respective jurisdiction of the state concerned. It is not denied before us that the circular has no legislative sanction and had been issued only by the state government exercising powers under Article 166 of the Constitution of India. In view of this, it can in no manner restrict the obligation conferred on station house officers to of respective police stations to abide by the mandate of Section 154 of the Code. In fact, a closer scrutiny of the circular shows that the Vigilance Department of the State of Punjab had no such intention. This circular puts into position a mechanism evolved by the State of Punjab for dealing with the complaints against the government officials which reach the government. It seeks to avoid harassment which the government servants may face in case unsubstantiated allegations made in complaint were to be acted upon before the authorities set up for the purpose are satisfied about the truth thereof. There being nothing in the circular which prevent the station house officers of respective police stations from taking cognizance of cases brought to their notices and thereafter proceed to investigate into them, the grouse of the petitioner is unfounded, as we have no doubt that action contemplated and the delay complained of is only regarding an administrative action which the state may like to initiate against the officials on account of misconduct that is alleged to have been committed by them. The obligation of the police force to our mind to respond promptly where any cognizable offence brought to its notice against any person, howsoever high, is in no way diluted by this circular. In this view of the matter, no legal infirmity which would call for any rectification at the hands of this court can be found in the circular, and therefore civil writ petition number 9256 of 2002 has to be dismissed. Ordered accordingly. The writ petition is consequently dismissed with no order as to costs.